The separation of state powers, legislature, judiciary and executive, is crucial to ensure fairness and upholding democracy. Judicial independence, in particular, plays a vital role in guaranteeing that laws are applied impartially, safeguarding individuals from unjust laws or potential overreach by the executive. While it is proper for Parliament and the executive to refrain from interfering in individual court cases or ongoing proceedings to protect judicial independence, it is important to note that both Parliament and executive have a primary role to address systemic issues through laws and policies, respectively. In this context, today's videos aims at analysing and reacting to David Davies' adjournment debate held yesterday, 8th of January 2024, which centred on Lucy Letby's trial. An adjournment debate in the House of Commons provides an opportunity to discuss matters of public concern without requiring the House to vote for a specific question. Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Before diving into these issues in detail, we would like to remind you to subscribe to our channel. Your support helps us continue providing the latest updates on our criminal justice system and furthers our mission to humanize it. Don't forget to like, share and comment to help expand the debate and broaden our reach. Thank you. Although Davies described the adjournment debate on his X account as focusing on the role of expert witnesses and the trial of Lucy Letby, the issues he addressed were in fact much broader in scope, and we appreciate him for raising them. In particular, he explored the general problem of miscarriages of justice, the interaction between the police and prosecutors, challenges associated with presenting statistical and medical scientific evidence in court, the limitation of appeals due to procedural strictness, and of course the recent criticism of the CCRC, particularly regarding its handling of Andrew Malkinson's case, with a specific focus on the time it takes the CCRC to process the applications it receives. Let's unpack all of that. On the topic of miscarriages of justice, Davies remarked,
"Now, sadly, none of us are strangers to miscarriages of justice. There have been simply too many. The Birmingham 6, the Guildford 4, the Stockwell 6, all the famous ones. But Exeter University Miscarriage Database lists nearly 500 people wrongfully imprisoned. And astonishingly, wrong forensic evidence is responsible for 81 cases, and which led in those cases to over 500 years of unjust imprisonment. And many of those cases involved caregivers convicted by medical experts' testimony asserting deliberate harm where causes of death were in fact natural."
It is important to note that this figure only includes convictions that have been overturned. It excludes numerous cases where defendants maintain their innocence but fail to achieve justice due to procedural hurdles in the appeal process and the system's resistance to acknowledge its own errors. Many of you may have listened to Dominic Kennedy's recent podcast on the Times The Story, which discusses the case of Eddie Guilfoyle. The CCRC referred Guilfoyle's case to the Court of Appeal in 1999, but it was refused. His second application to the CCRC was rejected in 2016 after a 5-year investigation. While this topic may warrant a separate video, the key takeaway here is that the Exeter database only tracks miscarriages of justice that have been overturned. So the problem is far more widespread than it appears. in relation to the interaction between police and prosecutor, David Davies referred...
His gut feeling was based on a coincidence. She was on shift for a number of deaths. And this is important, although far from all of them. Far from all of them. It was built on a poor understanding of probabilities that was to translate later into an influential but spectacularly flawed piece of evidence. Now, from the start of the case, Cheshire Police picked up on the doctor's statistical argument supposedly pointing to Letby. In April 2018, an officer on the investigation approached the leading statistician, Professor Jane Hutton, and asked her to put a figure on the likelihood of a nurse being on duty, quotes, during all the deaths and collapses, close quotes, in the unit. Of course, this is a false proposition, as Letby was not on duty for anything like all the deaths, as we'll see later. But that was glossed over at the trial. That notwithstanding, Professor Hutton informed the police that any proper statistical inquiry should not concentrate on one member from the outset. Instead, it required full, proper research into all possible explanations for any increase in babies collapsing, including their medical conditions and prematurity, as well as the broader performance of the unit. You'd think that would be common sense, really. Cheshire Police then signed a consultancy agreement with Professor Hutton. But then, in 2021, after Letby had been charged, the police wrote an email to Professor Hutton, and I quote it in terms: "We have had a further meeting this afternoon where we have informed the prosecutors we were looking into the validity of the statistical evidence in this case. The prosecutor has instructed us not to pursue this avenue any further at present." Now, this appears to be in direct contravention of the Code for Crown Prosecutors, specifically Part 3.3 of the Code. Prosecutors cannot direct the police or any other investigators.
3.2, which states that the police and other investigators are responsible for conducting inquiries into any alleged crime and for deciding how to deploy their resources. These includes decisions to start or continue an investigation and on the scope of the investigation. Prosecutors cannot direct the police or other investigators. While it might have been convenient for the police to use this as an excuse, they could have in fact pursued this line of inquiry independently, regardless of the CPS directions or suggestions. The police are solely responsible for conducting inquiries into any alleged crime and for deciding how to deploy their resources. Another issue Davies mentioned was statistical and medical evidence, which in fact, in its own words, represented his central argument of the debate.
In May 2017, Dowie Evans, a retired doctor who runs a business which provides highly paid medical expert evidence in court cases, approached the National Crime Agency to volunteer his services. Evans' opinion that Letby injected air either into the baby's veins, causing air embolism, or down the nasogastric tube into the stomach, stopping the baby's breathing, was one of the foundations, indeed probably the major foundation, of the prosecution case. This supposed evidence is hugely controversial. 3 months into the murder trial, Letby's defence team applied for evidence from Dowie Evans to be excluded due to an adverse judgment from a judge in a previous case, who said a report by Dr. Evans was, quotes, worthless and makes no effort to provide a balanced opinion, close quotes. In an extraordinary and, as far as I can see, unprecedented intervention, that very judge, Lord Justice Jackson, actually wrote the trial judge with his judgment on Dr. Evans attached, clearly indicating how unsuitable Evans was as an expert witness. Evans' assertion of murder by air embolism was entirely based upon a research paper from 1989, and its relevance in these cases have been robustly challenged by the actual author of that paper. Evans changed his opinion on several key issues during the trial. He's now accused by Letby's lawyer of changing his opinion again since the end of the appeal process. Now, Evans disputes this, but if you're interested, I suggest you compare Evans' evidence recorded in the trial transcript of November the 1st, 2022, with his signed statement to Channel 5 on the 3rd of August 2024, and decide for yourself. It's also the case that Evans has submitted a report to the police. What is extraordinary, however, is that the CPS, the Crown Prosecution Service, has refused to provide a copy of that report to Letby's current defence counsel. Extraordinary. Which brings us to the actual cases and causes of the deaths. 2 expert neonatologists, consultant working neonatologists, are working through the cases to establish the actual causes of the baby's deterioration and deaths. They're doing so thoroughly, so this is taking time. So far, they have completed 2 detailed case reviews, baby O and C. There are 5 more which will be completed in the near future. There is a great deal of evidence demonstrating that there are much more likely alternative causes of these tragic deaths than those put up by the prosecuting team. The most likely is that the hospital neonatal unit was not up to caring for these fragile children, either in resource or skill terms. And this shortcoming might have been compounded by other factors such as the Pseudomonas infection. Of course, the so-called expert evidence in this case largely amounted to putting together theories suiting the prosecution case, from the bogus statistical arguments through to the wrong diagnoses I've just detailed. Again, this problem is not new. In 2011, the Law Commission made a number of recommendations on precisely the handling of expert evidence. There's even a section in it entitled Inferring Murder from Unexplained Infant Deaths. These recommendations have not made it into law nearly 15 years later. It's past time this was put right.
He rightly referred to the fact that this is not a new issue. We also note that among the recommendations, recommendation 22 suggested that for trials on indictment before a judge and a jury, if the judge concludes at the end of the trial that the prosecution's case relies entirely or largely on disputed expert opinion evidence, the judge should 1. Consider whether to issue a cautionary warning to the jury regarding that evidence, and 2. If deemed appropriate, provide the jury with a tailored warning that reflects the specific facts of the case. The government, however, rejected this as well as all the other recommendations. We have referred to some of these issues in our video Criminal Evidence Roulette, the Risk of Statistics, which is linked in the description below. Regarding matters that can be brought before the Court of Appeal, Davies mentioned a technical problem.
There is case injustice, in my view, for a retrial, but there is a I won't say a technical problem. There is a problem. One of the problems we face is that much of the evidence was available at the time. I mean, what I have described is an expert analysis of the case notes which were there at the time, but it was simply not presented to the jury. This means the Court of Appeal can dismiss it, basically saying the defence should have presented it at the initial trial. It is in essence saying, if your defence team weren't good enough to present this evidence, hard luck, you stay banged up for life. Now, that may be judicially convenient, but it's not justice. This has been a historic problem in Britain, delaying the resolution of a number of miscarriage of justice cases.
We have raised this issue in our news session In the Name of Justice, which was aired in September 2024, in which we discussed the matter of Oliver Campbell, where we noted that no specific law prohibits raising on appeal points that were or could have been raised at trial. This principle has been developed entirely through case law and is grounded in considerations of jury supremacy, legal certainty, and the finality of decisions. We contend that in cases of suspected miscarriages of justice, the sole guiding principle and consideration should be the pursuit of justice. We argue that this issue warrants serious attention and should be addressed at legislative level. It is also a matter currently under review by the Law Commission on Criminal Appeals. However, despite the expectation that the Law Commission would release a consultation paper with provisional proposals in 2024, no updates on this matter have been provided, and the anticipated paper clearly has not materialized. Now, let's see what was the answer by the minister. Alex Davies-Jones, the Parliamentary Under Secretary of State for Justice, opted to give a response of convenience. While she correctly emphasized that it is an important principle of the rule of law that the government does not interfere with judicial decisions, David Davies raised broader issues of significance that could have been addressed by Davies-Jones in a constructive manner without specifically addressing the Lucy Letby's case. Instead of merely reiterating the current procedure, which has been the subject of numerous miscarriages of justice in the past, she could have offered a more thoughtful and meaningful response in light of the role of both Parliament and government to address systemic issues through laws and policies, respectively. In our view, her first misstep was to mechanically repeat Thirlwall's comments that much of this debate has come from people who were not present throughout the trial to hear the evidence in full. While this statement was already contentious when it was first made, it is even more problematic now in light of recent findings by two expert neonatologists instructed by the defense, as meticulously reported by David Davies. Their reports suggest that the cause of death in at least two of the babies was primarily due to suboptimal care. This was based on original medical notes that were made available to them. Her second misstep was to simply reiterate the current law and procedure regarding expert evidence and appeals without offering any constructive analysis. She made broad statements such as,
"The Court of Appeal have carefully considered the arguments put before them and delivered their judgment. The criminal justice system has well-established processes and procedures for how expert evidence is used and routes to challenge if any individual, including Ms Letby, maintains their innocence."
These broad remarks ignored the points raised by Davies, which are substantiated by the fact that numerous wrongful convictions have been overturned, demonstrating that the system is not functioning as effectively as it should. She also dismissed the fact that the Law Commission is currently reviewing criminal appeals, with that review still pending. There was no effort to engage seriously with Davies' concerns or to explore potential reforms that would allow certain issues to be raised appropriately in the future. She could, for example, have acknowledged that miscarriages of justice have occurred in the past and that we have not always been effective in addressing them, suggesting that we may need to delve deeper into these issues. Instead, she chose to perpetuate this idea of the infallibility of the system, the same very attitude which led Maxwell 5 to refuse to commute Bentley's sentence, or Reginald Moulding to dismiss a public inquiry into Bentley's case in 1972. And so history repeats itself. We do not doubt that judicial independence is a cornerstone of the rule of law and democracy. By refraining from interfering in individual court cases or ongoing proceedings, both Parliament and the Executive ensure that the judiciary can operate impartially and without external pressure. This maintains public trust in the fairness of legal decisions and the integrity of the judicial process. However, this must be balanced with Parliament's primary role to legislate and address systemic issues that arise within society, including those highlighted by judicial proceedings. When court cases reveal gaps, ambiguities, or injustices in the law, Parliament has the authority and responsibility to respond by enacting or amending legislation to prevent similar issues in the future. For example, when courts identify a systemic problem, such as procedural limitation in appeals, Parliament can debate and introduce reforms to address these challenges. Similarly, the executive branch is responsible for implementing laws and developing policies to address systemic issues. Through policies, resource allocation, and administrative oversight, the executive can tackle problems identified in the legal system without undermining individual courts' decisions. For instance, if systemic issues arise around the treatment of expert witnesses in trials, the executive can work with relevant agencies to establish standards or provide training to improve the process. While the judiciary applies the law in individual cases, Parliament and the executive focus on broader policy and legislative changes. Those roles are complementary. Courts identify problems through their rulings, and the legislative and executive branches respond to create a more just and effective system. This separation also ensures a balance of power. If Parliament and the executive confine themselves to only observing judicial outcomes without addressing systemic issues, it would risk stagnation and failure to address societal needs. While non-interference in individual cases protects judicial independence, Parliament and the executive have a vital role in addressing systemic issues through laws and policies. This balance ensures that the justice system evolves while maintaining its fairness and impartiality. And what do you think? Let me know in the comments below. Join us again as we sit and rise in this unique trial.